Hello, my name is Won Kidane. I'm a professor of law at Villanova University Law School. I'm also a partner at Addis Law Group. It's a small boutique international arbitration firm based in Washington, D.C., Addis Ababa, and Dubai. We do commercial arbitration and investor state arbitration work. I'm making this video as a part of ITA's What I'm Working On series. I'm also a member of ITA's Academic Council. So what I'm working on currently is an article, a law review article on the post-Chevron law of deference for investor state arbitration. It's an interdisciplinary analogy. I don't try to justify the methodology in the paper. So last June, when the United States Supreme Court overruled Chevron, this is in Loper Bright, the publicity that it got was that deference is gone. But there is an aspect of Chevron that the United States Supreme Court explained in Loper Bright that is not overruled, but clarified. There are two aspects to it. The first one is on the interpretation of a statutory ambiguity, whether the court owes deference to the administrative agency's own interpretation. The second aspect, which is least appreciated, or the part that got less attention, is the Supreme Court's decision in Loper Bright that the court's review of whether the administrative agency acted arbitrarily and capriciously required deference. And the answer to that, the second question, is actually yes. So the analogy that I'd like to draw is in investor state arbitration, ISDS tribunals almost invariably sit in judgment of certain actions that took place in the host state by host state agencies. It could even be the courts of the host states applying their own laws, making decisions according to their own procedures. A lot of literature covered deference in ISDS. For instance, Stephen Schill also talks about how tribunals just mention deference, but they don't consistently apply the notion. But even for him, deference is a standard of review. But what we see from Loper Bright as a template for analysis is deference could actually be a command of positive law. It's not always discretionary. And the way ISDS tribunals have used deference is also, as Stephen Schill also says, very varied. In Joseph Charles Lamar v. Ukraine, for instance, they have articulated the concept very well when they said, and I can quote them here, the arbitrators are not superior arbitrators. That's what they're saying. They're not superior regulators. They do not substitute their judgment for that of national bodies applying national laws. The international tribunal's sole duty is to consider whether there has been a treaty violation. A claim that a regulatory decision is materially wrong will not suffice. It must be proven that the state organ acted in an arbitrary or capricious way. And other tribunals have also said similar things. Another high-profile tribunal chaired by Vidir, co-arbitrators Kaufman Kohler and Bridget Stern, they've also unanimously concluded that a state can thus be, I quote, a state can thus be mistaken without being unreasonable. There are other tribunals like El Paso v. Argentina that didn't even employ the concept of deference at all. So what I argue in this article is tribunals must not only examine whether the concerned state action is materially wrong as a matter of the state's own law, but also determine whether the state action was arbitrary and capricious, right? Whether they apply indirect expropriation principle, FAT. At the end of the day, they must identify at least one or more offending actions or omissions. So in determining whether or not the state's actions are arbitrary and capricious, going back to Loper Bright, the idea of deference comes in again. There are various reasons why deference is required in secondary decision-making. It could be epistemological, right? There are many steps removed from the facts and, in fact, from domestic laws and their application. But primarily, what this template shows is it could be the command of the law that they apply. That if the law requires them to defer, they have no discretion not to defer. So my argument really is if they are applying indirect expropriation or FAT, and eventually they need to determine whether or not the state's actions are arbitrary and capricious. By the same token, they must be reviewing that aspect with some degree of deference to state actors. Still developing that notion, but it's the template that I'm trying to use for ISDS jurisprudence. So I hope it contributes somewhat to the ISDS jurisprudence, and I appreciate your attention, and thank you very much.